Hi, I'm Ian Hull, and I'm here to speak on 2 Minutes with Hull and Hull. I just want to finish up my thoughts from my last podcast dealing with the important considerations you might want to look at or actually think about if you're in a situation where you have a cross-jurisdictional matters. And I'm focusing on the comparison between Ontario and British Columbia just because it does bring a large volume of my practice. I see a lot of situations where those two provinces tend to be considerations in will planning matters. I talked last week about the wills variation provisions in the Act out in British Columbia. I want to talk about two other provisions just to illustrate that Ontario really is a lot further behind British Columbia from a statutory standpoint in wills law. And the British Columbia legislation, which has been amended since 2009 and as recently as up to 2014, with their legislation, they've allowed for much greater flexibility. I talked about the greater flexibility in terms of the court's role in gifting last time, but there's also two other easy illustrations. One is that in British Columbia, for example, marriage does not necessarily revoke a will. Well, in Ontario, if you get married and you have a will in place, by the act of getting married, you've essentially, at law, revoked your will. And that's something that a lot of people in Ontario don't always think about. So remarriage is an important time to refresh your will in Ontario. In fact, a vital time. Whereas in British Columbia, their legislation allows for some, I'll call it wiggle room. There's also some legislative wiggle room in British Columbia if the will isn't done perfectly. And they can fix a will a little bit easier and rectify a will a little bit easier because of their legislation than you can in Ontario, which sticks with a very rigid, unbending series of steps and rules that apply. So, although it's got some positives and negatives, I think it's important from a will planning standpoint to understand that, for example, British Columbia may have a different approach to many aspects of fundamental will planning that we do here in Ontario, and it can be helpful in the right circumstances when you have that cross-jurisdictional issue being raised. So thanks so much for joining me with 2 Minutes with Hull and Hull.